Welcome to another deep dive. Today, we're plunging into an area of law that is, well, absolutely fundamental to the fairness of trials.
Hmm.
But it's also incredibly complex, often controversial character evidence.
It really is. It's all about how and when someone's past behavior, their character, can actually be used in court.
And for this deep dive, we're working from some fantastic, really detailed materials.
Yes, and we should say this exploration is actually made possible thanks to the University of London. They've generously made these documents available to students for educational purposes.
That's right.
So we're really grateful for their contribution to learning, which allows us, to unpack these concepts for you in this way.
Absolutely. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And to all of you who are studying this topic, particularly if you're using those University of London materials and maybe getting ready for exams,
Yes,
we really want to wish you the very best of luck.
you've got this. Good luck.
Good luck indeed. So our mission today, basically, we're going to take this significant stack of source material, the statutes, the cases, the
I
commentary,
love it.
and try to guide you through the most important knowledge, the key insights on character evidence. We'll navigate the rules, the case law, hopefully help you understand what's really going on.
Okay, let's try and unpack this because it is a dense topic. The world of character evidence, it really underwent a seismic shift, didn't it? Particularly in criminal cases with the Criminal Justice Act 2003.
Oh, absolutely. We'll call it the CJA 2003.
Yeah, CJA 2003. Before that, evidence of a defendant's past behavior, well, it was often viewed with extreme suspicion, wasn't it?
Definitely. Generally seen as too prejudicial.
Too likely to make a jury think, oh, they've done bad things before, they must be guilty now.
Exactly. But the CJA 2003, it instituted some, well, truly radical changes.
It completely flipped the script in many ways.
It did. While civil cases, they largely stuck to a more traditional kind of relevance-based approach, criminal proceedings are now primarily governed by this comprehensive CJA 2003 framework, specifically Part 2 of the Act.
Right.
The Act aimed, to provide a clear statutory statement of the law, which was a major departure from the old common law rules.
But, as always, Parliament writes the law.
And then the courts interpret it.
Exactly. And the sources make it abundantly clear that the story didn't end with the act itself. There's this massive body of case law that's built up since 2003. Judges grappling with the statutory language, really shaping how these CJA provisions are actually applied in court.
That's spot on. So understanding this area isn't just about reading the Act. It's really about understanding that ongoing judicial dialogue and interpretation. That's where so many of the crucial nuances and, frankly, the complexities lie.
Okay, so before we dive headfirst into the full complexity of the CJA 2003, maybe let's ease in slightly. How is character evidence treated in civil proceedings? Does my past behavior matter there?
Generally speaking, it plays a much smaller, simpler role in civil cases compared to criminal ones.
Yeah.
The basic rule for good character is quite straightforward.
Okay.
Evidence of a party's good character is typically not admissible in civil proceedings. Civil trials are focused on the specific facts of the dispute. Did you breach the contract? Were you negligent? Not really about your overall moral standing.
Okay, so my stellar reputation for honesty outside of this, say, car accident case,
Fine.
it isn't relevant just because I'm involved in a lawsuit.
Exactly. That general good behavior isn't usually seen as directly relevant to proving or disproving the specific civil claim. Unless,
Always an exception.
always, if your opponent unfairly attacks your character, makes an unwarranted aspersion on your credibility or reputation during the trial, then you are permitted to introduce evidence of your good character,
Okay.
but only to counter that specific allegation. It's like a defensive shield, not an offensive sword.
Got it. A shield against an unfair attack.
What about bad character in civil cases, then? If I'm suing someone, can they bring up my past mistakes? Well, that's where the leading House of Lords case comes in. It's O'Brien v. Chief Constable of South Wales Police
Look, Brian, okay?
from 2005. You might see it cited with UKHL 26 or UKHL 36 or even 2 ACE 534. The House of Lords, which was the highest court then, gave really thorough consideration to this exact issue, the admissibility of bad character evidence in civil cases.
And what was the outcome? What test did O'Brien give us? That's the key thing, isn't it?
It is. O'Brien established a clear two-stage test. Remember this. 2 stages for civil bad character.
Okay, stage 1.
Stage 1. Is the evidence relevant to a matter in issue in the proceedings? That's the primary filter. If it's not relevant, it stops right there.
Simple enough. Relevance first, stage 2.
Stage 2. If it is relevant, should the court nonetheless exclude it? And this involves a balancing act.
Ah, the balancing act.
Exactly. Taking into account the potential prejudicial effect the evidence might have compared to its actual probative value, how much it truly helps the court determine the truth of a relevant issue.
Okay, relevance first, then this kind of cost-benefit analysis of prejudice versus actual value. What sort of things go into that balancing act at stage 2?
Well, the sources suggest factors like the strength of the evidence of the past, that character itself. How similar is the past behavior to the conduct being alleged now in the civil case?
Right.
How long ago did it happen? And how severe is the potential prejudice it might cause to that party's case? You weigh all that against how much it genuinely assists the judge or jury in deciding the facts relevant to this specific dispute.
So the core question is really, is this evidence more likely to unfairly bias the decision maker against the party because of their past, rather than actually helping resolve the current case?
Precisely. Is it more heat than light, essentially?
That two-stage test seems quite focused on relevance and fairness within the specific civil dispute. Now, the sources point out something interesting that came up kind of, by the way, obiter dictum in O'Brien.
Ah, yes, the obiter point. When the House of Lords in O'Brien was contrasting the civil position with the then-new CJA 2003 framework for criminal cases, they suggested, maybe a bit tentatively, that the CJA 2003 might have preserved the old common law requirement of enhanced probative value, for what used to be called similar fact evidence in criminal trials.
Ah, the old similar fact rule associated with cases like Boardman required that striking similarity.
Exactly, Boardman from 1975. That rule needed a really high degree of similarity or distinctiveness. Striking similarity was the phrase often used for past conduct to be admitted to prove a pattern or propensity.
But the sources immediately counter this suggestion from O'Brien, don't they? They flag up the Weir case.
Absolutely. The Court of Appeal, the Criminal Division specifically, in Weir, that's R.V. Weir from 2006, also cited as 2005 EWCA Crim 2866, directly addressed and explicitly rejected that obiter suggestion from O'Brien. Weir is absolutely critical because it definitively clarified the impact of the CJA 2003 on those old common law similar fact rules.
So what did Weir confirm about the old striking similarity test from Boardman in criminal cases? Is it dead?
Completely dead. Weir held that the CJA 2003 did indeed make that common law test of striking similarity entirely obsolete for criminal cases. It's
Yeah.
gone.
Right.
Under the CJA 2003, as clarified by Weir, if evidence of a defendant's bad character is relevant to an important matter in issue between the defendant and the prosecution, which is how the CJA frames propensity evidence, we'll get to that, that it is admissible. And crucially, it's admissible subject only to the court's specific exclusionary discretion found in Section 101.13 of the CJA 2003. There is no longer any separate, elevated common law hurdle like enhanced probative value or striking similarity that the evidence also has to jump over.
Wow, that is a massive difference. So the key takeaway here is civil cases use the O'Brien two-stage test relevance plus that balancing act.
Correct.
But for criminal cases, the old common law similar fact test, striking similarity, it's dead. Replaced entirely by the distinct, complex CJA 2003 statutory framework as confirmed by Weir.
Precisely. Civil is relevance-focused under O'Brien. Criminal is governed by the comprehensive, and as we're about to see, intricate CJA 2003 statutory scheme, with Weir confirming the death of striking similarity within that scheme.
Excellent. Now let's jump fully into the criminal trial context. The sources say the law on a defendant's good character, while maybe simpler than bad character, is still absolutely crucial.
It is. And its importance really comes to the fore in cases where the evidence against the defendant might be, well, a bit thin or contested.
Right.
The sources point to the Privy Council case of Campbell. That's Campbell from 2010, a UKPC case, also reported in the WLR.
Okay, Campbell 2010. What was the scenario there?
Campbell was on trial for murdering a police officer. The prosecution's case relied very heavily on the identification by a single witness.
Just one witness.
Just one. And Campbell denied being the person identified. The Privy Council, when they reviewed the case, made a very significant point about the role of a good character direction in exactly those circumstances.
What did they say was so important about the direction then?
Lord Mance, giving the judgment, stated that in a case like Campbell's, resting primarily on a single witness identification which the defendant denies, the absence of a good character direction was particularly serious. He said it deprived Campbell of a benefit in precisely the kind of situation where such a direction must be regarded as being of greatest potential significance for the defense.
Wow. So when the evidence against you is maybe precarious, your history of good behavior can become a really critical factor for the jury.
Absolutely. It gives the jury a legitimate basis to ask themselves, is a person with this history of good behavior likely to have committed this serious crime? And are they the kind of person who would be telling the truth now when they deny it?
Right.
It provides them with a positive attribute to weigh in the defendant's favor. And that's why, if a defendant is of good character, giving a direction about it to the jury is mandatory.
It's mandatory, not just discretionary.
Mandatory. That requirement comes from the leading court of appeal case in this area, which is R.V. Vi. That's Vi from 1993, reported in the criminal appeal reports and the weekly law reports.
Okay, Vi 1993. That's the key case for the direction itself.
Yes. In Vi, the Court of Appeal set out the standard structure, the two limbs, that a good character direction must contain. You need to know these two limbs.
Okay, let's make sure we nail these down. The two limbs of the Vi direction, what are they? Repeat them for us.
Okay, the two limbs are, first, the credibility limb. This tells the jury that the defendant's good character is relevant to their truthfulness, their credibility as a witness.
Right.
The idea is that someone who's of good character is more likely to be telling the truth. Now, this limb is only given if the defendant has actually testified in court, or if they've made pretrial statements denying guilt, what we call exculpatory statements, which the defense is relying on.
Okay, credibility only if they speak or rely on statements. What's the second limb?
Second, the propensity limb. This tells the jury that the defendant's good character is relevant to the likelihood of them having committed the offense.
Likelihood. Propensity.
Exactly. The thinking is that a person of good character is less likely to have behaved in the way alleged by the prosecution. And this propensity limb must be given in all cases where the defendant is deemed to be of good character, regardless of whether they testify or make statements.
Okay, so credibility limb if they speak or use statements. Propensity limb always if they're of good character. That brings us to the tricky question. What exactly does good character mean? The sources mention Aziz and then a crucial update from Hunter.
Right. The definition was explored quite deeply by the House of Lords in Aziz. That's Aziz from 1996, an AC case. However, over time, maybe partly driven by arguments and appeals, the application of the Vi principle seemed to expand a bit.
How so?
Well, commentators like Professor Monahan noted concerns that defendants with, some history were maybe successfully claiming entitlement to these directions in circumstances where it felt less appropriate, kind of pushing the boundaries.
This sounds like the scenario Lord Stein warned about in Aziz itself. He talked about judges being forced to give meaningless or absurd directions when a claim to good character was, quote, spurious, even if the defendant technically lacked formal convictions but had a history of similar dodgy behavior.
Exactly that. Lord Stein was worried about the law creating a kind of charade where the court had to pretend someone was of good character when, in reality, their conduct suggested otherwise, just because they didn't have a previous conviction on their record.
Right.
And the development of the law before the Hunter case arguably led to more situations where judges felt constrained to give directions in potentially misleading circumstances.
So how did Hunter address this issue and also grapple with the wider definition of bad character that the CJA 2003 introduced?
Right, Hunter. That's Hunter, Nigel, from 2015. An EWCA crim case, also in the criminal appeal reports. It was a really comprehensive review by the Court of Appeal. They aimed to clarify the scope of good character directions, partly in light of how the CJA 2003 defines bad character, much more broadly than just convictions. Hunter provided much-needed structure by essentially categorizing defendants.
Categorizing them. Okay, tell us about these categories from Hunter.
Hunter basically put defendants into three bins, if you like. First, absolute good character. These are defendants with absolutely no previous convictions or any other relevant bad character. Clean slate. They're entitled to the full Vi direction. Both limbs were applicable as of right. Mandatory.
Okay, absolute good character, mandatory direction, second bin.
Second, effective good character. Now, these are defendants who do have some previous convictions or other bad character on their record, but the judge decides, in their discretion, to treat them as if they are of good character for the purpose of the direction.
Ah, so the judge decides they are effectively of good character.
Exactly. And if the judge makes that determination, then they are also entitled to a direction as of right, just like the absolute good character group.
Right. Still mandatory if the judge deems them effective. And the third category?
Third, bad character. These are defendants who don't qualify as having absolute or effective good character. For defendants falling into this category, it is entirely at the judge's discretion whether to give any form of character direction at all.
Entirely discretionary.
Entirely. And if they do give one, what form it should take. It certainly won't be the full Vi direction, but maybe something modified or tailored.
So Hunter introduced significant judicial discretion, particularly for defendants who aren't pristine.
Mhm.
How did it define absolute good character then? Was it just no convictions?
Hunter adopted a notably narrower definition than the sort of general reputation idea that has sometimes been discussed after Aziz. The Court of Appeal, led by Khalid L.J. in Hunter, stated that an accused with any previous conviction, no matter how minor, how old, or how irrelevant it might seem to the current charge, could not be regarded as being of good character in the proper sense.
Wait, hang on. Even one old minor conviction means you are not considered absolutely of good character after Hunter?
That's the strict definition Hunter adopted for absolute good character, yes.
Yeah.
It's quite tough. However, that's where the second category, effective good character, comes into play.
Right, the judge's discretion.
A judge may decide to treat a defendant as having effective good character if and only if their bad character is deemed to be old, minor, and irrelevant.
Old, minor, and irrelevant. Do all three conditions have to be met together?
Yes, and this is a critical point from Hunter you must remember. Khalid L.J. explicitly stated that those three conditions, old, minor, and irrelevant, must be read conjunctively.
Conjunctively. All three.
All three must be satisfied for a judge to even have the discretion to treat a defendant as having effective good character and grant them the full vi direction as of right. This significantly restricts the circumstances under which defendants with any kind of record qualify for that mandatory direction.
And the decision on whether it is old, minor, and irrelevant, that rests entirely with the trial judge.
Yes, it's their discretionary call. And the Court of Appeal in Hunter made it very clear they would be very slow to interfere with the trial judge's exercise of this discretion, recognizing they are best placed to assess the specific circumstances of the case and the defendant's record in context.
So the net effect of Hunter is a really big shift, isn't it?
It is. It moved the law from being largely mandatory for pretty much anyone without a significant record to being much more discretionary for a large proportion of defendants who have some form of previous misconduct, however defined under the CJA.
Right.
This definitely addressed some of those concerns about the potential charade Lord Stein mentioned in Aziz by giving judges greater ability to decide whether a defendant's history genuinely warrants a full good character direction. And the sources note it has indeed led to fewer appeals on this point.
Okay, bringing it back to the violins, credibility, and propensity. Hunter dictates who is entitled to a direction. Does it mean judges can now just dispense with the vi direction entirely for some defendants?
Yes, essentially. For those defendants categorized as having bad character under the Hunter scheme, meaning they have previous convictions or misconduct that isn't deemed old, minor, and irrelevant, conjunctively, the judge has full discretion.
Full discretion.
They can choose whether to give any direction related to character at all. And if they do, as we said, it won't be the full vi direction, but rather something tailored. So, yes, post-Hunter, the judge can dispense with the mandatory vi direction for those in the bad character category. For those in the absolute or deemed effective good character categories, the direction remains mandatory, although subject to that crucial discretionary assessment for the effective group first.
Fascinating how the courts evolve the application of these fundamental principles over time. Okay, we've covered good character. Now let's brace ourselves for the real complexity. Evidence of bad character in criminal trials under the CJA 2003.
Right, this is really the heartland of the CJA 2003 reforms in this area.
Yeah.
And it represents a significant, well, radical departure from the common law. As Hughes L. just noted, in the Court of Appeal in Chopra, that's Chopra 2007, the crucial change brought by Part 2, Chapter 1 of the CJA 2003 is that evidence of a defendant's propensity to commit offenses of the kind charged,
Propensity?
which was prima facie inadmissible at common law, generally kept out, is now prima facie admissible under the CJA 2003.
That's a fundamental flip from generally out to generally in, provided you meet the new rules.
Exactly. But getting it in is subject to navigating the CJA's specific admissibility rules, often called the gateways. Before we hit those gateways, though, we absolutely need to understand the statutory definition. What does the CJA 2003 actually mean by bad character?
Okay, definitions first. What's the CJA's definition?
Section 98 of the CJA 2003 provides the starting point. It states that for the purposes of this act, evidence of a person's bad character is defined as evidence of or of a disposition towards misconduct on his part.
Okay, evidence of or disposition towards misconduct. And that term misconduct, what does that cover? Is it just crimes?
No, it's broader. Section 112 of the CJA 2003 defines misconduct as the commission of an offense or other reprehensible behavior.
Other reprehensible behavior.
Exactly. The explanatory note that came with the act indicate this was intended to be a broad definition, capturing more than just previous criminal convictions.
Reprehensible behavior. That sounds like a term the courts would have had to wrestle with and clarify. What has the case law said it means?
Yes, they certainly have. In Renda, that's Renda 2005, the Court of Appeal said that reprehensible, in ordinary language, suggests some element of culpability or blameworthiness.
Culpability or blameworthiness. Okay.
So it's not just behavior you might disapprove of. It needs to have a degree of fault attached. Scott 2009 illustrated this nicely by finding that merely irritating and upsetting behavior by a non-defendant was not reprehensible enough.
But other things were.
Oh, yes. McKenzie 2008 found that aggressive and impatient driving, even without specific convictions for those acts, was reprehensible. And Norris 2013 held that racist and violent behavior displayed on a GVD was also reprehensible behavior, so it's quite fact-specific.
So it definitely extends beyond formal convictions. What else counts as misconduct under this definition?
It certainly does. It includes interactions with the criminal justice system short of a conviction. For instance, receiving a caution can count as misconduct under the CJA.
A police caution?
Yes, but crucially, this only counts if it involves an admission of guilt by the person cautioned. That point came from Weir 2005.
Right, admission needed.
And perhaps surprisingly to some, even behavior that was the subject of an acquittal in a previous trial can potentially be considered misconduct under the CJA.
Really? Even if you were found not guilty?
Yes. This follows the principle from earlier law, like the House of Lords case of Z from 2000, and the CJA explanatory notes explicitly support this reading. Edwards 2005 confirmed this applies under the CJA. The acquittal doesn't erase the underlying behavior from potentially being considered misconduct.
That is a really wide definition then. So does that mean any evidence of someone's past behavior now has to come in through these CJA 2003 bad character rules? Is everything bad character?
No, and this is a really important distinction to grasp. Behavior that falls outside the CJA 2003 definition of bad character, meaning it's not misconduct, an offense or reprehensible behavior, and it doesn't show a disposition towards misconduct as defined by sections 98 and 112.1.
Okay.
That evidence is not automatically inadmissible just because it's outside the CJA definition. It can still be admitted the old-fashioned way at common law if it is relevant to a fact and issue in the case.
Can you give us an example of something that might fall outside the CJA definition but still be admissible because it's relevant?
Yes. The sources give a couple of helpful examples. In Manister 2005, the defendant was charged with sexual offenses involving a 13-year-old. Evidence came up that he'd had a sexual relationship with a 16-year-old 5 years earlier.
Okay.
The court considered this. They found it didn't actually qualify as reprehensible behavior under the CJA definition. Perhaps the age difference, 34 and 16, wasn't seen as culpable enough in itself in that specific context.
Right.
However, the court held it was admissible at common law because it was relevant to show a general sexual interest in young girls, which was an issue in the trial involving the 13-year-old.
I see. So relevant, but not technically reprehensible under the CJA. Any others?
Similarly, in Fox, that's Fox Charles Frederick, 2009 diary entries detailing fantasies about underage girls were admitted as relevant to the charges, even if the fantasies themselves weren't necessarily misconduct under the CJA definition.
Yeah.
The key was relevance.
Okay, so if it's relevant but doesn't meet that misconduct or reprehensible bar, it might still get in the old-fashioned common law way.
Correct. And Towsey 2019 is mentioned again as a useful recent case, providing a range of examples of what can constitute bad character evidence, including things like evidence of stated future intent, really demonstrating the breadth of that CJA definition.
Are there any types of evidence that are just automatically admitted as bad character under the CJA, sort of bypassing the main gateways entirely?
Yes. The CJA creates specific categories of evidence that are automatically admissible under Section 98 itself, meaning they are considered bad character for the act's purpose, but don't need to satisfy one of the main gateway conditions in Section 101 if they meet the S.98 criteria.
Which criteria are those?
There are two main ones in S.98A and B. The evidence is automatically admissible if it craves it. A has to do with the alleged facts of the offense the defendant is charged with. This basically covers misconduct that is inextricably linked with, or part of the narrative of, the crime itself.
Part of the story of the crime.
Exactly. Cases like McNeil 2007, Turnovianu 2007, and Sewell 2012 explore this, showing there isn't necessarily a strict time limit, although Sullivan 2015 cautioned against stretching this connection too far in time or space.
Okay, that's A. What's B?
Section 98B covers misconduct connected with the investigation or prosecution of that offense.
Like trying to interfere with the case.
Precisely. Things like trying to bribe a witness, intimidating jurors, or destroying evidence related to the current charge would fall under S.98B and be automatically admissible.
So, misconduct that is woven into the crime itself or into the subsequent investigation or prosecution gets in automatically without needing a main gateway. What about really old convictions? Can they become untouchable after a certain time?
No, interestingly, convictions that are considered spent under the Rehabilitation of Offenders Act 1975 can still be admissible as bad character under the CJA 2003, both for defendants and non-defendants. That act doesn't provide a shield against the CJA bad character rules.
Okay, good to know. And we touched on the assumption of truth briefly earlier. Can you just reiterate how that works?
Yes, Section 109 of the CJA 2003 introduces this rule specifically for the court's decision on admissibility. When the judge is deciding whether to let bad character evidence in, they can generally assume the evidence is true for the purpose of making that admissibility decision. There's a small caveat in S.109 too, but that's the general principle.
And that links to PACE.
It does. It's somewhat mirrored by Section 74 the Grata of the Police and Criminal Evidence Act 1984 PACE 1984, which states that past convictions are generally presumed to be true unless the defendant can rebut that presumption.
But crucially, the defendant can challenge the truth of it later, at the trial itself. That seems vital for fairness.
Absolutely vital. The assumption of truth under S.109 is only for the judge's admissibility ruling behind the scenes, as it were.
Yeah.
At the trial, in front of the jury, the defendant or indeed any person whose bad character evidence has been admitted is entirely free to contest the truth and accuracy of that evidence.
Okay, that's a critical safeguard. Any other miscellaneous CJA provisions worth just flagging up quickly before we tackle the main gateways?
Just a quick mention of a few others in Part 2 of the CJA. Section 107 allows the court to stop a case if the bad character evidence is so contaminated that a conviction would be unsafe. Section 108 provides some special rules for considering offenses committed when the defendant was a child. Section 110 imposes a duty on the court to actually give reasons for its rulings on bad character admissibility, which helps with transparency and appeals. And Section 112.3 clarifies that nothing in the CJA bad character chapter affects the existing restrictions on evidence about a complainant's sexual history under Section 41 of the Youth Justice and Criminal Evidence Act 1999, the YJCEA 1999. We'll come back to that interaction.
Right, so there are layers of complexity even before we get to the core admissibility rules. Now, the heart of the matter for defendant bad character, the 7 gateways under Section 101 of the CJA 2003.
Correct. Section 101.4 sets out 7 specific conditions, or gateways. If the prosecution, or in one specific instance, a co-defendant, can show that the defendant's bad character evidence meets any one of these 7 gateway conditions, then it is potentially admissible against the defendant, subject, of course, to other rules and discretions.
7 gateways. Okay, let's start with maybe the simpler ones, the less controversial, less litigated gateways first.
Gateways A and B are usually fairly straightforward. Gateway A is where all parties to the proceedings agree to the evidence being admissible.
Simple enough if everyone consents, it can come in.
Exactly. Gateway B is where the evidence is adduced by the defendant themselves, or it's elicited by the defendant, perhaps in cross-examination of a witness.
So the defendant brings it up themselves.
Yes. This often relates back to the defendant trying to assert their own good character, perhaps clumsily or maybe strategically introducing some element of their past to explain something else.
Okay, so Gateway A, agreement. Gateway B, the defendant introduces it. What about the other 5 gateways, the ones based on relevance? These sound like the main battleground.
They absolutely are. This is where most of the complexity and the arguments arise. They are.
It is important explanatory evidence.
It is relevant to an important matter in issue between the defendant and the prosecution.
It has substantial probative value in relation to an important matter in issue between the defendant and a co-defendant.
It corrects a false impression given by the defendant.
Yeah.
And Gateway G. It counters the defendant's attack on another person's character.
Okay, C, D, E, F, and G. That list feels dense already. Are there overarching safeguards that apply to some or all of these relevant-based gateways, protections for the defendant?
Yes, absolutely. There's a critical exclusionary discretion, particularly for gateways D and G. This is found in Section 101.3. You really need to remember S.1013.
Section 101.3. Okay, what does it do?
It's a crucial safeguard. It states that on the defendant's application, the court must not admit the evidence if quote, "It appears to the court that the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it." Must not admit. That sounds like a strong obligation on the judge, not just it may exclude. How does that compare to other discretions, like under PACE? It's considered a stronger form of words than the general exclusionary discretion found in Section 78(1) of PACE 1984, which says the court may refuse to allow evidence if it would be unfair. Section 1013 imposes a mandatory duty to exclude if that threshold of unfairness is met. It's a higher hurdle for the prosecution to overcome if challenged.
Are there other specific safeguards linked to particular gateways?
Yes, specifically for Gateway D. The one about relevance to an important matter in issue with the prosecution, Section 1033, provides another potential ground for exclusion. It says the court can refuse to admit the evidence under Gateway D if it appears to the court that it would be unjust to admit it.
Unjust, okay.
And Section 1014 explicitly links the fairness consideration under S1013 for Gateway D to taking into account the effect of any lapse of time since the bad character event occurred. So time is a specific factor for D.
Can you give an example where evidence was excluded under these safeguards?
Chrysostom 2010 is a good example where bad character evidence was found to have been wrongly admitted. The court felt it failed the S10113 because it was merely prejudicial, only serving to sort of blacken the general character of the defendant rather than having sufficient proper relevance to an issue.
So even if evidence technically gets through a gateway, the court still has to perform this balancing act under these safeguards, particularly for D&G weighing fairness and justice.
Precisely. And it's important to remember the point from Height in 2005. There's a distinction between the evidence being admissible through a gateway, which the judge decides, and the use to which the jury can actually put that evidence once it's admitted. The judge will direct the jury on its potential relevance, but the jury ultimately decides what weight and value, if any, to give it in the end.
Okay, let's dig into the relevance-based gateways themselves, starting with Gateway C, Important Explanatory Evidence, Section 101C.
Right. Gateway C is available only to the prosecution. It's read together with Section 102. The purpose here is really about providing necessary context for the jury. It's material that helps them properly understand and assess the other evidence in the case. It's about making the narrative flow and be comprehensible, filling in essential background.
Can you give us a classic example of Gateway C in action?
The key case always cited for this is Pronick 2006. The defendant was charged with attempted rape of his partner.
Okay.
The court admitted evidence of his previous conviction for assaulting her and also an earlier non-charged incident where he had allegedly raped her. The Court of Appeal held this was necessary material under Gateway C. Because without this background, the jury simply couldn't properly understand the nature of the relationship between the defendant and the complainant. And without understanding the relationship, they couldn't effectively assess the evidence from both sides about the alleged attempted rape. It provided crucial context.
So it's about filling in essential blanks for the jury's understanding of the main story.
Yes, providing that crucial context. Now, Davis 2008 distinguished between two types of explanatory evidence that might fall under Gateway. First, evidence that's explanatory of the central issues of the case, like the relationship history in Pronick.
Okay.
And second, evidence of bad character that's kind of unavoidable to provide context or adds probative value to a secondary issue, like identification. Chohan reported with Edwards, 2006, is often cited as an example of the second type. An eyewitness identification was deemed stronger because the witness frequently bought drugs from the defendant.
Ah, so revealing his bad character as a drug dealer was unavoidable context.
Exactly. It helped explain the witness's familiarity with him, which bolstered the identification evidence, even though drug dealing wasn't the charge.
Okay, context is key for Gateway C. But there's a really strong warning about how this gateway must not be used, right? Something the courts have emphasized.
Absolutely. And this is a critical point the sources repeatedly emphasize, and you must remember for exams. Gateway C must not be used as a backdoor way to introduce evidence of the defendant's propensity, their tendency to commit offenses.
Propensity evidence belongs elsewhere.
Exactly. Propensity evidence falls squarely under Gateway D, which has its own specific rules and safeguards.
Why is it so important not to use C for propensity? What's the danger?
Because doing so allows the prosecution to effectively evade the safeguards specifically attached to Gateway D. Most notably, Section 1014 requires a court to consider the effect of any lapse of time when considering the fairness of admitting propensity evidence under Gateway D.
With the time lapse factor.
That safeguard does not apply to Gateway C. So if you let propensity evidence sneak in through Gateway C, you bypass that crucial fairness check regarding how old the evidence is. The Court of Appeal has been very strict on this in cases like Davis, Deanne from 2011, and Lee from 2012. And the Supreme Court in Mitchell 2016, looking at similar NI law, stated emphatically that a case of propensity cannot and must not be dressed up as a case of important explanatory evidence.
Okay, message received.
Genuine context only for Gateway C.
Right.
Don't try to sneak propensity in that way. Now let's move to the big one, Gateway D, relevant to an important matter and issue between the defendant and the prosecution. Section 101D. This sounds like the main route for propensity evidence.
It is. Gateway D is also available only to the prosecution, and it's read together with Section 103. First hurdle. What's an important matter? Section 112.1 tells us it means a matter which is of substantial importance in the context of the case as a whole, not trivial.
Substantial importance. And what are the main kinds of important matters in issue that typically fall under this gateway? Section 103.1 specifies two primary ones, and these are the ones you'll encounter most often. A, the defendant's propensity, their tendency to commit offenses of the kind with which they are charged, and B, their propensity, their tendency to be untruthful.
Propensity to commit similar offenses or propensity to be untruthful.
Exactly. While these are the two main ones listed, case law shows other matters can sometimes also qualify as important matters at issue under this gateway.
Okay, let's start with propensity to commit offenses, Section 103. This is a huge area. What guidance have the courts given on applying this part of gateway? D, it sounds potentially very prejudicial.
It is, and the courts are very aware of that. The key guidelines come from the Court of Appeal in Hansen v. Hansen from 2005, reported in the WLR. Hansen was a conjoined appeal where the court provided really important general observations on how to apply Section 101, particularly Gateway D, propensity.
Okay, Hansen 2005. What are the core questions Hansen said judges should ask themselves when considering admitting propensity evidence based on past convictions?
Hansen outlined three essential questions, and you should try to remember these. 1, does the defendant's history of convictions actually establish a propensity to commit offenses of the kind charged? It's not just any propensity, but a propensity relevant to the specific current allegation.
Right.
2nd,
2, does that specific propensity make it more likely that the defendant committed this specific offense they are charged with now? The past behavior must have genuine probative force for the current case. Does it actually help prove they did this crime?
and the third question deals with fairness.
Yes. 3, is it unjust to rely on these convictions, and would the proceedings be unfair if they were admitted? This explicitly brings in those statutory safeguards we mentioned, Section 103, unjust, and Section 113, unfairness.
Those three Hansen questions seem crucial. Hansen was also critical of the way the statute itself defined offense categories, wasn't it, in Section 103.2?
Yes, Hansen noted that the statutory offense categories listed in S.1032, things like theft offenses or sexual offenses, can be quite broad, potentially grouping together very different types of behavior.
Right.
The court stressed that just because previous convictions fall into the same statutory category or happen to have the same legal description as the current offense, that does not automatically mean they should be admitted under gateway. The focus must always be on whether they genuinely demonstrate a relevant propensity in the specific factual context of the crime currently alleged.
So, just having past convictions for theft doesn't automatically mean I have a propensity relevant to, say, a robbery charge, even though they might be in the same broad category?
Not necessarily at all. Tully and Wood 2007 provides a good illustration echoing Hansen. In that case, theft convictions had been admitted against a defendant charged with robbery. The Court of Appeal felt these convictions had little probative force for the robbery charge unless the circumstances of the thefts were very similar to the circumstances of the robbery alleged.
So similarity of circumstances is key, not just the legal label. Exactly. The emphasis is on the similarity of the underlying behavior. The more similar the circumstances of the past offenses are to the present allegation, the greater the potential probative force.
Does the past conduct have to be the same type of offense legally?
No. Johnson, Chad, 2009, is a case showing that propensity can sometimes be established by convictions that are not of the same legal description or statutory category as the current offense, if they reveal a relevant underlying pattern of behavior.
How many previous incidents or convictions are typically needed to show propensity under gateway? Is there a magic number? 1, 2, 3.
Hansen stated there is no minimum number required by the statute. However, they gave a very strong caution. A single previous conviction, even for an offense of the same description or category, will rarely be sufficient on its own to demonstrate propensity.
Rarely sufficient. Okay, so a single one is usually not enough. When might a single conviction be enough to get past the Hansen hurdle?
A single conviction might be capable of establishing propensity in limited circumstances. For example, if it reveals a tendency towards very unusual behavior, the examples often given are things like child molestation or arson, or if it displays a very distinctive modus operandi, a specific, unusual way of committing the crime.
A signature crime.
Kind of, yes.
Hmm.
Again, similarity between that single past event and the current alleged offense is absolutely crucial. And the Court of Appeal, McDonald 2007, stressed that judges must exercise great care before admitting a single conviction for this purpose. It's the exception, not the rule.
But courts have found single convictions admissible for propensity sometimes. It's not impossible.
No, it's not impossible. Despite the caution, the Court of Appeal has upheld the admission of single previous convictions as relevant to propensity in various cases. The forces mention examples including sexual offenses, Brown 2011, Kamara 2011, Sullivan 2013, and even in murder cases where the circumstances showed a distinctive pattern or behavior. Bowman and Lennon 2014, Glenn and Wright 2006, Jackson 2011. So while rare and requiring very careful analysis by the judge, it is possible.
Okay. Going back to Hansen's third question about fairness, the unjust test in S11033 and the unfairness test in S11003, what specific factors does the judge consider in that balancing act for Gateway DD propensity evidence?
The judge will look closely at the degree of similarity, or lack thereof, between the past convictions and the current charge. They'll also consider the respective gravity or seriousness of the past offenses compared to the current one. And crucially, remember what we said earlier about Weir?
Yes, Weir killed off the old striking similarity test from Boardman.
Exactly. So while similarity is considered as part of the Hansen analysis and the fairness assessment, the old common law test of striking similarity is entirely obsolete as a separate hurdle for admissibility under the CJA 2003, where 2006 confirmed that. The focus now is solely on demonstrating relevant propensity under the CJA criteria and passing the statutory fairness tests.
Does the strength of the prosecution's overall case, aside from the bad character evidence, matter when deciding whether to admit it under Gateway D?
Yes, absolutely. Hansen stated very clearly that the judge must always consider the strength of the prosecution's other evidence. If there is no or very little other evidence against the defendant, Hansen said it is unlikely to be just or fair to admit previous convictions under Gateway, no matter how relevant they might seem on paper.
So you can't just use bad character to prop up a really weak case.
That's the principle. Croft 2013 affirmed that bad character evidence shouldn't be used under Gateway D simply to bolster a weak case. However, Bowman and Lennon 2014 did clarify that the prosecution doesn't necessarily need to establish a full prima facie case first before the bad character evidence can be considered. The strength of the other evidence is just one important factor in the overall S.1013 and S.103 fairness assessment.
What about the age of the convictions? Does lapse of time affect admissibility under Gateway D?
Yes, the age of previous convictions is a relevant consideration. Section 1014, remember, specifically requires the court to consider the effect of any lapse of time on the fairness of admitting evidence under Gateway D.
Right, S10114 and time lapse.
However, it's important to note that even a conviction that is technically spent under the Rehabilitation of Offenders Act 1975 can still be admitted to show propensity under the CJA. Being spent doesn't automatically exclude it.
So how should the judge weigh the time lapse?
Duper 2008 is a key case here. A conviction was quashed because the judge failed to properly consider the time lapse as required by S.1144. Duper explained that lapse of time must be considered from two perspectives. First, how does the age of the conviction affect its probative value in demonstrating a current propensity? Does it still show how they might behave now?
Okay.
And second,
how difficult does the passage of time make it for the defendant to fairly explain the circumstances of that previous offense? Memories fade, witnesses disappear. So both probative value and fairness of response are affected by time.
there's clearly a lot for the judge to balance under Gateway D. Who makes the final decision about whether the evidence actually proves propensity, the judge or the jury?
That's a crucial distinction. The judge's role at the admissibility stage under Gateway D is to decide if the evidence is capable of establishing the relevant propensity following the Hansen principles. That was confirmed in Chopra 2007 and Brima 2007.
Capable of establishing it. But it is entirely for the jury to decide whether, having heard the evidence, they conclude that it actually does show propensity and, importantly, what weight they should give to it in the context of all the other evidence. The Court of Appeal is generally slow to interfere with a judge's admissibility ruling unless it's seen as plainly wrong. M 2006 is cited as an example where they did intervene. A 20-year-old shotgun possession conviction was held simply incapable of showing a current propensity relevant to a firearm offense years later.
Does the type of defense run like whether the defendant completely denies being involved versus offering an innocent explanation for their actions affect whether propensity is an important matter under D?
No, the sources indicate that the defendant's propensity to commit offenses of the kind charged generally remains an important matter in issue under Gateway D, regardless of the specific defense strategy. Whether it's a complete denial, I wasn't there, or an innocent explanation, I was there, but propensity can still be relevant. Wilkinson, 2006.
And what about prejudice? We know there's the fairness test, but can evidence that clearly shows propensity still be excluded just because it makes the defendant look really bad?
Yes, absolutely. That's precisely the purpose of the S1013 fairness test and the S1033 unjust test. They exist to exclude evidence where the prejudice outweighs the probative value. Banabu 2012 is a notable, though perhaps rare, example where the Court of Appeal actually quashed a conviction on this basis.
What happened in Banabu?
A previous rape conviction had been admitted under Gateway D in a trial for sexual assault. The Court of Appeal found that, due to dissimilarities between the past and present offenses, the rape conviction had very limited actual probative value for showing propensity in the current case, but it carried an extremely high prejudicial effect that risked distracting or biasing the jury. They concluded the unfairness under S.1013 made the conviction unsafe.
Okay. We focused mainly on previous convictions for propensity to offend, but does Gateway D cover other forms of bad character, like the reprehensible behavior we discussed?
Yes, it does.
Yeah.
Propensity evidence isn't limited to just formal convictions. Derek Barron, 2010 is a good illustration. The defendant was charged with murdering his ex-wife after she started a new relationship.
Right.
Evidence of his history of obsessive sexual jealousy, stalking and assaulting previous partners whenever they formed new relationships, was admitted under Gateway D. It wasn't necessarily all convictions, but it showed a relevant propensity to react violently in these specific circumstances.
Okay, that's a deep dive into propensity to commit offenses under S1003-1A within Gateway D. What about the other main important matter listed there, propensity to be untruthful, S.031B?
Right, the untruthfulness limb of Gateway D.
Yeah.
Hansen also commented on this. The court felt that not all previous convictions, even for offenses involving dishonesty like theft, necessarily demonstrate a propensity to be untruthful in the specific context of giving evidence.
When would they be most likely to show that propensity then, according to Hansen?
Hansen suggested they are most likely to show this propensity where 1. The defendant was actually disbelieved after giving evidence in a previous contested trial, so the court essentially found they lied under oath before. Or 2. The previous offense itself was committed in a way that inherently involved untruthfulness, such as obtaining property by deception, which required making false representations.
And we mentioned Campbell had a significant, perhaps controversial impact here, a different Campbell case.
Yes, Campbell 2007, the bad character Court of Appeal case, not the good character Privy Council case. Campbell 2007 made a very restrictive suggestion regarding S103B. The Court of Appeal proposed that an important issue regarding untruthfulness propensity under this gateway is likely to arise only in cases where telling lies is actually an element of the offense the defendant is currently charged with.
Like perjury or fraud.
Exactly. And even then, the court suggested it would likely only be significant if the past lies were themselves criminal, in which case the evidence would probably be admissible anyway as propensity to commit offenses under S103.
So Campbell, 2007, basically argued that S.1031B, the untruthfulness limb of Gateway D, is largely redundant or unnecessary.
That was the clear effect of its reasoning, yes. It led commentator Professor Muirfield to famously and critically call S1031B a dead letter after Campbell.
Has that view held? Is it a dead letter?
Well, not all subsequent cases have strictly followed Campbell's very restrictive view. Balogun 2008 provided some counterexamples where untruthfulness propensity was considered an important issue, even though lying wasn't a legal element of the current charge. So the exact scope of, say, 1031B remains somewhat debated post-Campbell, but Campbell certainly cast a long shadow over it.
Okay. Are there any other less common important matters in issue under Gateway D besides the two main types of propensity to offend or be untruthful?
Yes. Case law has shown that Gateway D can apply to other matters, provided they are of substantial importance in the case. Examples given in the sources include SCJ 2006, where the defendant's propensity to supply cocaine was held relevant to the issue of identification. Perhaps it explained why he was in a certain location or known to certain people. Another is Hay 2017, where a robbery conviction was admitted to counter a defense of innocent association with a co-defendant. In Eastlake 2007, where bad character evidence was admitted as relevant to proving the defendant's identity as the perpetrator, maybe through a pattern linking him to the crime.
All right, Gateway D is complex, primarily covering propensity to offend or be untruthful, plus potentially other important matters, but always subject to those crucial fairness and justice safeguards under S.1013 and S.1003. Let's move to the next one. Gateway E. This is about an important matter and issue between the defendant and a co-defendant, Section 10101.
Right. Gateway E is distinct because it's available only to a co-defendant who wants to introduce evidence of another defendant's bad character. The prosecution cannot use this gateway. It's read together with Section 104.
So this is for cutthroat defenses, where one defendant blames the other.
Exactly. That's the typical scenario. Defendant A says defendant B did it and wants to show defendant B's bad character to support that claim, making B look less credible or more likely to be the culprit.
What's the test for admissibility under Gateway E? Is it the same standard as Gateway D?
No, it's a higher standard, a more demanding test than Gateway D. The evidence must have substantial probative value in relation to an important matter in issue between the co-defendants.
Substantial probative value. Okay, that's definitely a higher bar than just relevant to an important matter needed for Gateway D.
Yes, the inclusion of substantial deliberately sets that higher bar.
And if that higher bar is met under Gateway E, is there a safeguard like the S1013 fairness test that applies to D and G? Can the judge exclude it if it seems unfairly prejudicial to the defendant whose character is revealed?
Now, here's where it gets really interesting and quite striking. If the court is satisfied that the evidence meets that substantial probative value test under Gateway E, there is no power for the court to exclude that evidence.
No power at all.
None. Not under the CJA 2003, and not even under Article 6 of the European Convention on Human Rights, the right to a fair trial. Musson 2007 confirmed this quite starkly. No discretion to exclude if Gateway is satisfied.
No discretion at all, even if it's incredibly prejudicial to the other defendant. That seems harsh.
It does seem harsh from the perspective of the defendant whose character is revealed. The logic, presumably, is that if the evidence has substantial probative value for one defendant's defense against their co-defendant, that defendant's right to put forward their defense outweighs the potential prejudice to the co-defendant whose character is being exposed. It prioritizes the adducing defendant's fair trial rights.
Are there any limitations on this powerful gateway?
Yes, there's one specific limitation in Section 104.1. A co-defendant cannot use Gateway E just to adduce evidence that another co-defendant merely have a general propensity to be untruthful. It has to be more specific than that. The law is also described in the sources as being in a somewhat uncertain state about precisely what is needed for one co-defendant's case to be seen as sufficiently undermining another's defense to trigger this gateway.
Right, so for Gateway E, high bar, substantial probative value, crucially no power to exclude if that bar is met, and a limitation on attacking general untruthfulness propensity. That contrasts sharply with Gateway D. Let's look at Gateway F now. Correcting a false impression. Section 101.
Gateway is available only to the prosecution, and it's read together with Section 105. Its primary purpose is essentially to allow the prosecution to rebut a false impression about their character that the defendant has deliberately sought to convey to the court or jury. It effectively replaces some of the old, complex common law rules about a defendant putting their character in issue.
How much bad character evidence can come in under this gateway if a false impression is made? Can the prosecution open the floodgates?
No, there's a key limitation here based on proportionality. Evidence is only admissible under Gateway if it goes no further than is necessary to correct the specific false impression that has been created. It has to be targeted rebuttal.
How can a defendant create a false impression that triggers this?
A false impression can be created by the defendant making an express or implied assertion about themselves, which is misleading. This assertion can be made through statements they make, or even through their conduct, for example. The way they dress or perhaps behave in court could potentially contribute to a false impression. It can occur in court while giving evidence or out of court in statements relied upon.
Does simply pleading not guilty or denying the specific charge count as creating a false impression? That seems like a fundamental right.
No,
Yep.
And this is a crucial safeguard you absolutely must remember. Merely denying the charge or pleading not guilty does not count as creating a false impression for the purposes of gateway.
Okay, good.
A defendant is perfectly entitled to defend themselves vigorously without automatically putting their general character in issue in this way. Where 2005 and 2011 confirm this principle, it has to be something more positive, an assertion that creates a misleading picture. Renda 2005 also touched on Section 105(3), which deals with the possibility of the defendant actually withdrawing the assertion that created the false impression, potentially to prevent the bad character evidence from being admitted under F.
Okay, so Gateway F is about actively misleading the court about your character, not just exercising your right to mount a defense. Finally, the last relevance, Gateway. Gateway G. This one counters the defendant's attack on another person, Section 1011G.
Right. Gateway G is also available only to the prosecution, and it's read together with Section 106. This gateway is triggered when the defendant makes an attack on the character of someone else involved in the proceedings.
Usually a witness.
Most commonly a prosecution witness, especially the complainant, but it can include other people too.
What sort of attack triggers this? Does it have to be really aggressive?
Section 106(2) provides a definition of what constitutes an attack. It's actually quite broad. It can include casting imputations about the other person's character, suggesting they are untruthful or dishonest, or even just using abusive language towards them. Section 106(1)(c) also confirms that such attacks made by the defendant in pretrial police interviews also fall under this rule and can trigger the gateway.
And if an attack is made, what's the consequence? Can any previous bad character evidence of the defendant then become admissible?
Potentially, yes. If an attack is deemed by the judge to have been made, the gateway licenses the admissibility of any previous conviction or other bad character evidence of the defendant. It's a very wide potential scope.
Wow. Is there any safeguard here, like the fairness test?
Yes. Crucially, unlike Gateway E for co-defendants, the judge does have the discretion to exclude the evidence admitted under Gateway G. The safeguard is Section 101(3), the same fairness test we saw applying to Gateway D. So even if an attack is made, the judge must still exclude the resulting bad character evidence if its admission would have such an adverse effect on the fairness of the proceedings.
Okay, so there is a fairness backstop for G. What's the reasoning behind this gateway? Why should a defendant be penalized with their own bad character just for challenging a witness, maybe legitimately?
The stated purpose, according to cases like Singh 2007, is to allow the jury to understand the source of the allegations being made against a witness, especially complainants. The idea is that if the defendant is attacking someone else's character, the jury should know about the defendant's own character to help them assess who is more likely to be telling the truth.
Puts the defendant's character in the balance.
It's also framed sometimes as protecting witnesses from potentially gratuitous or unfair attacks on their character by a defendant. Ball 2005 is often cited as a straightforward example. The defendant called the complainant a slag in his police interview. That was clearly deemed an attack triggering gateway.
Does it matter if the attack is actually a necessary part of the defense? Like, I didn't do it, she's lying because she has a motive.
Apparently not. The courts have held that an attack for the purposes of this gateway can occur even if what the defendant says is a necessary component of their defense strategy. That came from Singh and Lamaletti 2008.
So even if you have to say the witness is lying to explain your innocence, that's still an attack.
It seems so. Again, simply denying guilt is not an attack. But alleging that police officers, for instance, deliberately fabricated evidence is generally considered an attack, whereas merely suggesting they misinterpreted something or made an honest mistake might not be. Williams 2007 made that kind of distinction.
This Gateway G seems quite controversial from that perspective. Isn't it inherently unfair to make defendants choose between properly challenging a potentially untruthful witness and risking having their own entire past paraded in court?
It is very controversial, yes. And commentators like Professor Redmayne have strongly criticized it, for example, in his work The Law Commission's Character Convictions. He fundamentally questions the rationale of Gateway G, asking why defendants should effectively be penalized for making potentially legitimate challenges to a witness's credibility. If the attack is legitimate and necessary for the defense, why should they pay a price in the form of their own bad character being revealed? If the attack is gratuitous or irrelevant, it should arguably be stopped for other reasons, not used as a trigger to admit prejudicial evidence about the defendant.
It's a real dilemma for the defense. Is the standard of relevance for evidence admitted under Gateway G the same as for Gateway D, propensity evidence? Does it have to show untruthfulness?
No, and this is another key difference that makes Gateway G potentially very wide-ranging. Gateway G has no explicit requirement, unlike S103 for Gateway D, for the defendant's bad character evidence to show a propensity to be untruthful or even to have substantial probative value on any specific issue. As Singh confirmed, the restrictions that operate under Gateway D regarding relevance, particularly the stricter criteria suggested by Hansen and Campbell for propensity, are absent for Gateway G.
So the evidence just needs to be bad character, and it counters the attack, subject only to that general S.1013 fairness test.
Essentially, yes. Which means evidence admitted under G might not have much direct bearing on the issues in the case, beyond generally painting the defendant in a bad light, yet it could still potentially get past the judge if the fairness test isn't met.
So if bad character evidence does get admitted under Gateway G, because I attacked a witness, can the jury then use that bad character evidence for other purposes, like deciding if I have a propensity to commit this crime, even if it wouldn't have got in under Gateway G?
Potentially, yes. Remember our discussion of Heighton 2005.
Vaguely, remind me.
In Heighton, evidence of previous convictions was admitted against the defendant under Gateway G because he attacked the complainant's credibility by accusing them of lying. The judge then directed the jury that they could also consider that evidence as relevant to the defendant's propensity to commit the offenses charged, which would normally fall under Gateway D.
Ah, okay.
This illustrates that once evidence is properly admitted through one gateway, its potential relevance isn't necessarily strictly limited to that specific gateway's purpose, provided the judge gives the correct directions to the jury about how they can legitimately use it.
Which again highlights that danger the Court of Appeal warned about in Davis v. Aaron Lee, the risk of evidence slipping in through a potentially less stringent gateway, like C or G, and then being improperly used by the jury for the purposes of a more stringent one like D, propensity, effectively bypassing the intended safeguards for propensity evidence.
Exactly. The judge's directions on the use of the evidence are absolutely vital. DN emphasized that the judge's decision on which gateway the evidence is admitted through is usually a great help in identifying how the evidence can legitimately be used and which issues it is relevant to for the jury. They need that clear guidance.
Okay, we've navigated the definition, the automatic admissions under S.98, and all 7 gateways under S.101, along with their specific rules and safeguards. Let's just return briefly to the assumption of truth under S.109 and what happens if the bad character evidence isn't a nice, clean conviction, but a disputed allegation.
Right. As we said, Section 109 means the court assumes truth for the purpose of deciding admissibility. But the defendant can always contest the truth of the evidence at trial. That applies even to past convictions, although Section 74 of PACE 1984 creates a rebuttable presumption that convictions are true.
What about evidence that isn't a conviction or even a caution, just mere allegations of past misconduct that the defendant completely denies ever happened?
These are far more likely to be disputed by the defendant at trial, naturally. And this raises the significant practical problem of what the courts call satellite litigation.
Satellite litigation, mini trials within the main trial.
Essentially, yes. Where the main trial gets derailed while everyone argues about whether this alleged incident from 10 years ago actually happened or not. It requires calling witnesses about the past event, cross-examination. It could become a whole separate trial within the trial.
And why is satellite litigation considered problematic, apart from taking up time?
It can severely affect the fairness of the trial as a whole. It risks distracting the jury from the main issues they need to decide about the actual crime charged. It can make the overall case much harder for them to follow and understand. Cases like McAllister 2009, McKenzie 2008, and Edwards 2005 all emphasize the need for judges to guard against this danger.
So should judges consider this risk when deciding admissibility?
Yes, the risk of generating excessive satellite litigation is a relevant factor for the judge to consider when deciding whether to admit contested bad character evidence, usually under the fairness tests in S.1013, CJA 2003, or the general discretion in S.78 PACE 1984.
What did the Supreme Court say about this risk in relation to the CJA discretion in the Mitchell case?
In Mitchell 2016, interpreting the very similar Northern Ireland legislation, the Supreme Court discussed the application of the mandatory exclusionary discretion, equivalent to our S.1013. Lord Kerr opined that this discretion requires the judge to actively consider if admitting the contested evidence would have such an adverse effect on the fairness of the trial, partly due to satellite litigation, that it must be excluded.
Right.
He even suggested that exclusion might often be the preferable course in such cases, because the adverse effects of satellite litigation on the trial's fairness could be very hard to adequately offset later on with just a direction to the jury telling them to ignore the distraction.
So Even if the alleged past conduct seems relevant, the practical headache and fairness implications of having to litigate it could be strong grounds for exclusion.
Potentially, yes. It's a serious consideration. However, it's not an automatic bar. Gillespie 2011 reiterated that evidence of non-conviction bad character can sometimes still be admitted despite these dangers if its probative value is considered sufficiently high to outweigh the risks.
Speaking of directions, what specific instructions must the judge give the jury when bad character evidence is admitted, especially if it's disputed evidence?
The judge is under a mandatory duty to direct the jury whenever a defendant's bad character evidence has been admitted against them. The sources outline the necessary components of this direction, and these are absolutely critical for ensuring a fair trial.
Okay, what must the direction include?
Firstly, the judge must clearly identify the specific issue or issues to which the bad character evidence is potentially relevant. And, just as importantly, they should often specify the issues to which it is not relevant to avoid misuse.
Be specific about relevance. What else?
Secondly, the jury must be reminded that the bad character evidence is just part of the evidence in the case as a whole. It does not of itself prove the defendant's guilt of the current charge. It's just one piece of the puzzle.
Don't jump straight to guilt. Third point.
Thirdly, the jury should normally be cautioned against placing too much emphasis on the bad character evidence. This is particularly important for propensity evidence, following the guidance from Hansen. The direction aims to prevent the jury from being unfairly prejudiced and simply convicting based on the defendant's past rather than the evidence for the current crime.
Is there ever a situation where the judge might not give that caution about placing too much emphasis, or maybe modify it?
Yes, the Crown Court Compendium, which provides guidance to judges, notes a possible exception. If the bad character evidence is genuinely hallmark evidence, meaning it's directly and powerfully relevant to the core issue, perhaps a very distinctive modus operandi that strongly points to the defendant.
The signature crime again?
Yes, in such cases, a warning not to convict wholly or mainly in reliance on it might be inappropriate because its probative force is considered so strong and central. But that's likely rare.
Campbell, the good character one, is mentioned again regarding the detail needed in directions.
Yes, Campbell 2010 provided guidance recommending that judges give very specific directions, carefully linking the relevance of the bad character evidence to the particular facts of the case and the specific issues the jury is actually considering. General boilerplate directions are unlikely to be sufficient when dealing with complex and potentially prejudicial bad character evidence.
And the case of Lever is highlighted as a real cautionary tale about getting these directions wrong.
Absolutely. In Lever 2006, the defendant's conviction was quashed, precisely because the judge failed to adequately direct the jury on the relevance of the bad character evidence. A past conviction for indecent exposure had been admitted. The Court of Appeal held it was potentially relevant only to one of the two charges the defendant faced, rape, as potentially showing a propensity to degrade women. But it was irrelevant to the other charge, GBH, and also irrelevant to the defendant's general truthfulness.
And the judge didn't make that clear.
Exactly. The judge failed to make these crucial distinctions clear to the jury about how they could and couldn't use that indecent exposure conviction. That failure led to an unsafe conviction. It really underscores the vital need to specify relevance clearly, often on a charge-by-charge or issue-by-issue basis.
So the judge's direction is what bridges the gap between the admissibility decision, getting through a gateway, and the jury's actual use of the evidence.
Exactly. It reinforces that heightened point about the distinction between admissibility, which the judge decides based on gateways and safeguards, and the weight or value the evidence actually has, which the jury decides, but only based on the potential relevance the judge directs them on.
And those warnings from Davis, DN, and Lee?
Yes. About evidence admitted through less stringent gateways, like C or perhaps G, being improperly used by the jury for the purposes of a more stringent one, like D, propensity.
That just reinforces why correct, specific direction on use is so vital.
It really does. Even if the evidence could theoretically have been admitted under gateway, if it actually came in via another gateway, the conviction might be unsafe without that precise direction telling the jury if and how it relates to propensity. DN highlighted that the judge's decision on which gateway the evidence is admitted through is supposed to assist in identifying those legitimate uses for the jury.
What about directions when the bad character evidence is disputed, like those mere allegations we discussed, rather than an admitted conviction or something the defendant accepts happened? How should the jury approach that?
This is an area where the Supreme Court in Mitchell 2016 significantly clarified and actually altered the previous approach, especially for cases involving multiple allegations.
Okay, what was the previous approach?
The earlier position, often attributed to the Court of Appeal case of Lowe 2007, was generally understood to be that if the bad character evidence consisted of several alleged incidents that hadn't resulted in convictions or weren't part of the current charges, the jury had to decide if each separate incident was proved to the criminal standard beyond reasonable doubt.
Incident by incident.
Yes. And if they weren't sure about a specific alleged incident, they had to disregard that piece of evidence entirely when considering propensity.
And Mitchell changed that approach. How?
Yes, Mitchell 2016, interpreting very similar Northern Ireland legislation, adopted a different stance, specifically for cases involving several alleged incidents of similar behavior being used to show propensity. Lord Kerr, giving the judgment and following principles from an earlier case called Nguyen 2008, held that the proper issue for the jury in such cases is not necessarily whether they are sure about the truth or accuracy of all aspects of each individual alleged incident.
Not incident by incident, then.
No. Instead, the crucial question for the jury is whether they are sure that the propensity itself has been proved, considering the evidence about all the alleged incidents in the round.
In the round. What's the reasoning behind evaluating propensity that way, rather than requiring proof of each separate past allegation?
The Supreme Court in Mitchell gave two interrelated reasons for this in-the-round approach. Firstly, they noted the inherent improbability of a number of alleged incidents, each bearing strong similarities to the current charge, all being falsely made up against the defendant. This collective improbability is something the jury is entitled to consider.
Makes sense. What was the second reason?
Secondly, they stated that obvious similarities between multiple alleged incidents can provide mutual corroboration, where each alleged incident lends support to the others, making the overall pattern seem more likely to be true. The decision about propensity, Lord Kerr suggested, isn't about evaluating isolated episodes in hermetically sealed compartments. It's about evaluating the evidence about the alleged pattern of behavior overall.
That in-the-round approach from Mitchell is a really important clarification for directing juries in cases involving multiple similar allegations used for propensity. Okay, so we've spent a lot of time on the defendant's character, good and bad. What about the bad character of other people involved in the trial, witnesses, victims, maybe third parties, basically anyone who isn't the defendant?
Right, that's covered by a separate section of the CJA 2003, Section 100. This specifically governs the admissibility of bad character evidence relating to any person other than a defendant in the proceedings. The term non-defendant is broadly defined.
Does the CJA definition of bad character we discussed earlier, misconduct, reprehensible behavior from sections 98 and 112.1, apply to non-defendants too?
Yes, the fundamental definition is the same. So case law interpreting reprehensible behavior for defendants is usually relevant here too. Also, those automatic admissibility rules in Section 98A and B, evidence relating to the facts of the offense or the investigation, can potentially apply to evidence about a non-defendant if it fits those criteria, Machado 2006.
What's a key difference between the rules for adducing a defendant's bad character under S101 and adducing a non-defendant's bad character under S100?
A really significant difference, and one to watch out for, is this. When a defendant wants to introduce evidence of a prosecution witness's bad character, the complex Section 101.1 gateways and, importantly, the Section 101.3 fairness test that protect defendants regarding their own bad character simply do not apply.
They don't apply, so the witness doesn't get that S1013 fairness protection.
No. The admissibility of a non-defendant's bad character is governed entirely by the distinct rules set out in Section 100, although, ironically, as we saw with Gateway G, if the defendant attacks the prosecution witness's character while trying to get their bad character in under S100, the prosecution might then be able to introduce the defendant's bad character under Gateway G.
Right, it's a tangled web indeed. Are there any other special considerations for non-defendants, particularly complainants in certain types of cases?
Yes. Crucially, for complainants in sexual offense trials, there's another layer of protection. Evidence that might otherwise seem admissible under Section 100 CJA 2003 is subject to additional and very strict admissibility conditions under Section 41 of the Youth Justice and Criminal Evidence Act, 1999, YJCEA 1999.
Section 41 YJCEA. That restricts evidence about sexual history.
Exactly. Section 103 of the CJA 2003 explicitly confirms that the CJA bad character provisions don't override the S.41 restrictions. Scott 2009, the case we keep mentioning, is very important here as it delves deeply into how Section 100 CJA and Section 41 YJCEA interact, particularly concerning evidence of prior alleged false complaints made by a complainant in a sexual case. It's a very sensitive area.
Okay, so bearing in mind the S.41 overlay for sexual offense complainants, how does evidence of a non-defendant's bad character actually get admitted under Section 100 CJA itself? What are the limited circumstances allowed?
Section 101 CJA 2003 sets out three, and only three, conditions under which such evidence can be given. And unless the third condition agreement applies, it requires the leave of the court, the judge's permission to be admitted.
Okay, what are the three conditions in S.101?
1. The evidence is important explanatory evidence.
Yeah.
2. The evidence has substantial probative value in relation to a matter in issue in the proceedings. And D. That matters an issue of substantial importance in the context of the case as a whole. This one has two parts. 3. All parties to the proceedings agree that the evidence should be admitted. S.101C.
So leave of the court is needed for the first two relevance-based conditions, A and B. If the judge finds that those conditions are met, do they then have a discretion to refuse leave or exclude the evidence anyway, perhaps on grounds of fairness, like under S.1013 for defendants?
No, and this is another key difference you must grasp. The sources speak clearly that if the judge finds that the evidence does meet the tests under S.1011 or B, meaning it is important explanatory evidence or R, it does have substantial probative value on an issue of substantial importance, they have no discretion to exclude it.
No discretion to exclude, really?
None. The grant of leave is essentially tied directly to whether the statutory test is met. If it's met, leave must be granted and the evidence comes in. The sources note there's little further guidance on the principles governing the judge's decision to grant or refuse leave beyond simply determining if the stringent S.100 test itself is satisfied.
Okay, let's look briefly at those two conditions requiring leave. First, important explanatory evidence under S.100(a). Is that the same as for defendants?
Yes, this condition is essentially the same concept as Gateway C for defendants under S.101(c). Its purpose is to provide necessary context for the jury to understand the case properly. The case of Miller 2010 is given as an example where evidence exposing a non-defendant witness's potential motive for testifying might be admitted under this gateway as important explanatory context.
And condition 2, the main one, substantial probative value in relation to an issue of substantial importance, S.101b.
Right. This is probably the most common route for attempting to admit non-defendant bad character evidence. The test is twofold. The evidence must have substantial probative value relating to a matter in issue, and that matter in issue must itself be of substantial importance in the context of the case as a whole. Both substantial hurdles must be cleared, read with S.100(b), and the Act gives factors for assessing substantial value. Yes, Section 103 lists various factors the court must regard, like the nature or number of events, when they occurred, etc., plus any other relevant factors, when assessing whether the probative value of the evidence reaches that substantial threshold.
Can you give an example where evidence might relate to something important but still not meet the test under S.100(b)?
Braithwaite 2010 provides an illustration. The court acknowledged that the evidence might relate to an issue of substantial importance, for example, witness credibility, but found that the specific evidence itself didn't have sufficient probative value to meet the substantial threshold required for admission under this gateway. So you need both substantial importance and substantial value. Recent cases like R.V. Hackett 2019, where an appeal succeeded due to failures in applying the test, and R.V. Day 2019, confirming a single old offense with a distinctive feature could potentially show propensity even for a non-defendant, continue to apply these principles.
Does S.101b cover both propensity and credibility for non-defendants, like Gateway D does for defendants?
Yes. Unlike the specific split for defendants under S.103, propensity to offend versus propensity to be untruthful, S.101b covers evidence relevant to both the non-defendant's propensity, e.g. propensity to violence, if relevant to an issue like self-defense, and their credibility as a witness. The sources mention cases like Bovell and Dowd's 2005, S. Andrew 2006-2007, and H. 2010 as examples where propensity evidence for non-defendants has been considered under this section.
Where is non-defendant bad character most likely to be admitted under S.101b in practice?
It's most commonly admissible, or at least argued for, where the non-defendant's honesty or credibility as a witness is being seriously questioned, and their past bad character is relevant to assessing whether they should be believed.
And how has that term substantial probative value been interpreted in the context of witness credibility? Is it a high bar?
Well, after some conflicting early decisions,
Wow.
Stevenson 2006 versus S. Andrew 2007, the courts seem to have generally taken a relatively wide view of substantial probative value when it comes to non-defendant witness credibility.
Wider than for defendants.
Yes, it seems so. This has meant that the scope for cross-examining a witness about their general credibility using their past bad character has arguably been broader under S101B than the scope for adducing evidence to show a defendant has a propensity to be untruthful under the apparently strict interpretation of S16 post-Campbell. Osborne, reported with Renda 2006, supports this wider approach for non-defendants.
So it's potentially easier to attack a witness's general credibility with their bad character under S100 than it is to prove a defendant's propensity to be untruthful under S1001D. That seems inconsistent.
It does appear somewhat inconsistent, and Professor Muirfield, among others, has highlighted this apparent discrepancy with the stricter approach taken in Campbell regarding defendants' untruthfulness propensity. However, Brewster 2010 clarified that substantial probative value for non-defendant credibility evidence doesn't mean the evidence must conclusively prove that the witness is dishonest or lacks credibility. It just needs to be sufficiently persuasive for a fair-minded jury to reasonably question whether the witness's evidence is believable.
Are there any limitations on the type of non-defendant evidence allowed under S100-01B? We talked about satellite litigation risks earlier with defendants. Does that apply here too?
Yes, very much so. Because of the significant risk of getting bogged down in satellite litigation, the courts are generally very cautious about admitting mere allegations or police reports concerning non-defendants that haven't resulted in convictions or cautions as evidence under S1001B. Cases like Braithwaite 2010 and Miller 2010 emphasize this caution.
So satellite litigation is a legitimate reason for the judge to refuse leave under S100, even though there's no general discretion to exclude once the test is met. How does that work?
Good question. The risk of satellite litigation comes into play when the judge is assessing the second part of the S103 factors, whether the evidence has substantial probative value in the context of the case as a whole. If admitting the evidence would create a massive distracting sideshow, satellite litigation, that can legitimately lead the judge to conclude that its actual probative value in the context of this trial is not substantial enough to warrant admission under S100-01B. Desai 2013 confirmed that satellite litigation risk can diminish jury understanding and is therefore relevant to the S103 assessment.
I see. It feeds into the substantial value assessment itself. Now, the sources suggested taking a detailed look at Scott 2009 again, as it really brings together many of these non-defendant issues, including the S.41 interaction. Can we walk through the key points from that case one more time to consolidate?
Certainly. Scott is a complex but very important case. It dealt with the proposed bad character evidence of a non-defendant, the complainant, in a sexual offense trial. The evidence the defense wanted to use included witness statements and police reports, CRS reports, detailing previous complaints the complainant had apparently made to the police, some allegedly false.
What were the key legal questions the Court of Appeal considered in Scott?
They addressed several crucial points. First, they rejected the defense argument that the evidence was automatically admissible under S98A or B CJA 2003, related to facts investigation. It wasn't. Second, they had to decide if the evidence about the prior complaints actually amounted to bad character under the CJA definition. They concluded that some of the alleged behavior, like being irritating or upsetting, did not meet the standard of reprehensible behavior.
Okay. What about the evidence that wasn't CJA bad character?
For those parts, they considered admissibility under the common law based on relevance, but ultimately held it wasn't sufficiently relevant to the issues in the trial to be admitted that way either.
Right. So some of it wasn't even CJA bad character, and the rest wasn't relevant at common law. What about the evidence that potentially did qualify as CJA bad character for a non-defendant? How did they approach its admissibility?
For the evidence that did potentially fall within the CJA bad character definition, the court considered its admissibility under Section 101B, the substantial probative value, substantial importance test. They held that some of the proposed evidence did relate to a matter in issue under S101B, specifically the complainant's consistency and honesty as a witness in making allegations clearly an issue in a sexual offense trial.
The trial judge had apparently ruled some of that evidence didn't have substantial probative value. Did the Court of Appeal agree with the trial judge on that point?
No, this was a key area where the Court of Appeal found the trial judge had erred. They concluded that certain aspects of the past complaints evidence did have substantial probative value regarding the complainant's credibility when viewed against the factors listed in Espinal 003.
And they clarified the lack of discretion.
Yes. Importantly, they took the opportunity in Scott to correct an error in an earlier judgment, Carr 2008, that had wrongly suggested a residual discretion to exclude evidence under S-100 even after the statutory tests were met. Scott firmly reiterated that there is no such discretion. They also confirmed again that concerns about satellite litigation are legitimate factors to consider under S-103 when assessing whether evidence truly has substantial probative value in the overall context of the case.
And what about the other part of the S-101B test, substantial importance? Did the trial judge err there too, according to the Court of Appeal?
Yes. The Court of Appeal also found the trial judge was wrong to conclude that some of the evidence lacks substantial importance for the purposes of S-100-01B. They viewed the complainant's credibility in a sexual offense trial as being inherently a matter of substantial importance to the case.
Finally, how did Scott deal with the complex interaction between S.100.00 and S.41 YJCEA 1999, specifically regarding prior alleged false claims of sexual assault? Does S.41 block that evidence?
This is a very complex aspect. Section 112.3, CJA 2003 is the link, confirming CJA doesn't override S.41 YJCEA. The court in Scott wrestled with whether prior alleged false claims of sexual assault fall under S.41, which restricts evidence of a complainant's sexual behavior.
And the conclusion?
The conclusion from the case law discussed in Scott and subsequent cases is nuanced. Broadly, evidence of prior provably false complaints might potentially be admissible under S.100 CJA, but it's subject to very strict conditions and doesn't necessarily fall neatly into the category of sexual behavior automatically restricted by S.41. However, any attempt to introduce evidence relating to a complainant's sexual past, even allegedly false complaints, is subject to extremely careful scrutiny due to the high risk of prejudice, unfairness, and potential deterrence to genuine complainants. It's handled very cautiously.
So even with all that complexity regarding S.41, what was the final outcome in Scott based on the errors in applying S.1001B?
Given the significant errors the Court of Appeal identified in the trial judge's reasoning and application of Section 101B regarding the admissibility of the non-defendant complainant's character evidence, they concluded that the defendant's conviction was unsafe and allowed the appeal. Scott is a vital case for illustrating the practical application, the difficulties, and the interaction of many of the non-defendant bad character rules.
That detailed breakdown of Scott really does help to see how these intricate statutory provisions and the case law interpreting them are applied in practice. It's definitely a lot to take in.
It is, but walking through the reasoning in key cases like Scott, Hansen, Hunter, Vi, O'Brien, Weir, Mitchell, that really helps solidify your understanding of these specific tests and interactions. Repetition of those key names is important.
We've definitely taken a deep dive today. We started with the relatively simpler rules for character evidence in civil cases under O'Brien. Then we moved firmly into the criminal sphere, covering the mandatory but post-Hunter increasingly discretionary good character directions derived from Vi and clarified by Aziz and especially Hunter.
The two limbs, credibility and propensity.
Exactly. Then we spent significant time on the complex CJA 2003 framework for defendant bad character, navigating the definition in S.98 and S.11, the automatic admissions under S.98 and B.
And then the 7 gateways under S.1011, particularly the relevance-based ones. C, important explanatory evidence. D, important matter and issue propensity. E, issue with co-defendant. F, false impression. And G, attack on another.
Remembering the crucial safeguards under S.1013 and S.1003, especially for D and G, and that distinction between admissibility and use from heighten.
And the rules around disputed evidence and jury directions, including that significant shift introduced by Mitchell on the in-the-round approach for multiple allegations.
Finally, we examined the distinct rules for the bad character of non-defendants under Section 100 CJA. Noting the requirement for leave, the high substantial probative value test in S.101B, the lack of exclusionary discretion if that test is met.
And its interaction with Section 41 of the YJCEA 1999, using Scott as a key, if complex, example.
Yeah.
It's clear that mastering this area really requires careful attention to the specific wording of the CJA 2003 provisions, the extensive body of case law interpreting them, like Hansen, Hunter, Weir, Mitchell, the precise tests for admissibility through each gateway, the specific safeguards, and when they apply, the judge's discretions, and importantly, the lack of discretion in certain circumstances like Gateway E and S100.
And the critical importance of correct, clear, specific jury directions on how to use any character evidence that is admitted.
It's a dense but absolutely vital part of evidence law for ensuring fair trials.
It certainly is. And the ongoing development of the law through case law, constantly refining how terms like reprehensible behavior, important matter, substantial probative value, and even attack are applied, shows that this area is anything but static, doesn't it?
Definitely not static.
Which leads us to a final thought for you, the listener, to consider as you process all this information. Despite the ambitious attempt in the CJA 2003 to create a comprehensive, codified statutory scheme for bad character evidence, has the sheer volume and complexity of the resulting case law shown that evidence of character is perhaps inherently resistant to rigid codification? Does it constantly challenge the courts to find that difficult, maybe elusive balance between allowing juries to consider genuinely relevant information about people's pasts and protecting individuals from unfair prejudice based on those same pasts?
It's fundamental tension, isn't it?
Yeah.
Right at the heart of character evidence, and one the law will likely continue to grapple with for a long time to come.
A complex and endlessly fascinating area indeed. Thank you for joining us for this deep dive into character evidence.
Our pleasure. We truly hope this structured exploration, working through the University of London materials, has helped clarify these challenging concepts for you.
And again, from us and from Sinorbit Academy, Sri Lanka, good luck to all of you preparing for your exams. We hope you feel a little more ready to tackle the complexities of character evidence now.